Welcome back to Beyond the Bench, the podcast from Mountain States Legal Foundation, where we explore the cases, people, and principles shaping the fight for liberty in America. Today, we are joined by Ivan London, Director of the Center for American Prosperity and Energy, aka CAPE, here at Mountain States. Ivan, great to have you, and thanks for joining us for a conversation.
Thank you. I'm excited for this, actually. I've got myself worked up for it, ready to go.
There we go. We're all warmed up. We're all stretched out.
For stretched or stressed? Both could be true.
Honestly, both, to be honest. But for listeners who may not know you, how would you describe the kind of work you do here at Mountain States Legal Foundation?
Well, like you said, I'm the director of CAPE, Center for American Prosperity and Energy. My background is in litigating, as in having fights about issues in whatever form they come up, involve energy, the environment, natural resources. These things tend to go together a lot, and we find a lot of ways to fight about them. And that's sometimes not because we want to. So I was practicing a law firm, big law firm, for like 15 years before I've been here, although I was on the litigation board here for a little while. And there are ways to find fights, and sometimes fights find you. But for the ones I've handled, there's always been revolving around questions of the energy, the environment, natural resources. And as I grew into my practice a little bit, increasingly understanding how our U.S. Constitution has an overlay there, right? That's kind of, the root of the issue, the root of the fight. And there's actually a roadmap for how you deal with that fight, which, fortunately for me, has been very successful.
That's good.
Which is the U.S. Constitution.
Yeah.
It helps you a lot because most of these, there are some things that are business to business, different companies fighting against each other about a contract. And like that. But a lot of the work I've done over my career, which is longer than I realized it was, as I was just talking about it right now, make me feel kind of old.
I'm sorry.
No, I'm making myself feel old. A lot of the work I've done has involved the government telling a company or a person, a group, what they can and can't do. And at what point is that? Well, okay, that's fair. And at what point is that? Well, that's not fair. And the places where it's not fair or it's close call, especially the close calls, that's where I started getting involved a long time ago, really, in my career, but came to Mountain States to really work in that space, right? Because usually those close calls are really, really, really important.
Yeah, I've noticed.
I love it.
I've noticed it's a huge pipeline to go from
That's
like
a pun,
kind of
right? That's a pun. Oh, that's
yeah. It's a natural resource pun. If you didn't get it, I've noticed it's a. I mean, okay, now I'm going to reuse it.
You did not even mean that. Did
no,
you?
I didn't. I'm not going to lie.
You
no,
know what?
It was intended, but it was unintended.
Yeah.
But it's a huge pipeline to go from major law, kind of these big practices, into what is now constitutional law and where you're at Mountain States. So did you go to school for that? Like, is that what you got your degree in? Was constitutional law, or was it, or kind of more big business practices, or is that where you always?
None of the above is the answer.
Oh,
I
okay.
Tell you I had a real clear planning on that decision. I'd be lying to you. I didn't. Actually, I was more on a professor track. I have a master's degree also.
Interesting.
And I was thinking about going to get a PhD. My dad's a PhD. My wife's dad's a PhD. I was thinking more of being a professor and teacher, which is probably a bad outcome for when I talk in things like this, because I kind of go on forever.
It's okay.
But I'll shamelessly brag a little bit. You have a little room for that?
Yeah, of course.
As I was finishing my master's degree, I had taken the LSAT as a backup plan.
As a backup plan?
As a backup plan.
Oh, it's interesting backup plan.
Well, I'm good at taking tests.
You love taking tests.
I love it.
Yeah,
exactly.
with the master's and a law degree.
I'm a little competitive. So I had done that. Then I also won an international paper award for students on macroeconomic modeling of energy use. I'm happy to go in further. I don't know if this is the right venue for to go further on that.
Okay.
But I was invited to go speak about that as like a 22-year-old. And everyone kind of clapped and then turned around. I was like, well, that's great. And I kind of felt like it wasn't the same thing as getting my hands dirty, like getting in there.
So what do you mean by that? Like getting your hands dirty?
Getting my hands dirty. Like what I had done is created a math model, an elegant math model, a very small one, made it better, about an energy issue.
Mm.
And that's great. Probably contributed to some science there. But it didn't really affect anyone's lives. And I didn't have any lawyers in my family, but I thought, well, I do know some lawyers who are like friends' dads or friends' moms.
Yeah, you always got a friend's dad who's
Yeah.
like a lawyer somewhere.
I think the lawyers are like doing the same thing, but they're like in the fight. Now, I could have been right or wrong about that. I'm telling you, this is like, I'm not saying that I was justified in thinking that at the time. But in the meantime, I'd taken the LSAT and ended up going to law school to kind of, with the idea of getting my hands dirty. So I wouldn't say it's like there's a way you can trace a clear line from my law school experience to now. There's also a way you could, the reality
more of a tidal wave,
exactly,
kind of left to right, not so
maybe
linear.
life works that way sometimes. I'm not sure, but in my experience, it has. So I didn't go to law school thinking I'm going to fight for the Constitution. And here I am.
Was there ever a moment? It could possibly be in law school, but even maybe outside of law school, where that really drew you to constitutional law and specifically like property rights litigation, like in the first place?
Property rights tangentially, but certainly. So I worked just the background for 15 years or so for like big law firms, as we were alluding to, right? And like I said, a lot of the cases were just a company against another company. You totally feel fulfilled fighting for your client against another company and client. But the cases that really got me going, I hope it's not racist, it turned me on, right? Where, the government says we have to do this. And my clients are saying, well, the government says we have to. I'm like, well, have you guys thought about that yet? Just not just how you do it, but like, do you have to? And I was lucky to experience that just early in my career. And, it wasn't every case. But as I got older and I got a few more cases like that, it really, really appealed to me to find ways to take on these cases, which frankly is not always easy when you're an expensive lawyer. Yeah. Where you have to ask this question like, well, the government says, but why do they get to say? And frankly, I hope this is not controversial in this podcast, but I'm not an anti-government guy. But also there are lines, there are limits, right? It's like, well, when you go beyond there, you can't. And I think that people often don't think that way. They just take kind of what's given to them, they're told, as opposed to thinking about it constructively. Like, well, I don't know if we have to. And if we don't have to, then what do we say here? So I've really been drawn to the work again. I wasn't a Mountain States lawyer when I started helping with Mountain States cases. Because I was on the Litigation Advisory Council for a few years too.
Okay, nice. Before you started MSLF.
Yeah, exactly. So I was on the advisory board.
I did not know this.
Oh, okay. Well, so I was on the advisory board here before I joined as an actual lawyer for this firm.
Were you ever on like co-counsels and stuff like that?
Yeah, exactly. And all respect to a friend of mine, Jeanette Brown, who was the former general counsel here. She and I had worked together before in the law firm environment. And when she was hoping to get a little help on a case, she asked me to help, and I was thrilled. It's a cool case. It's our Stolenex case. I mean, it's a great case. Oh my God, I can go to well, we have time.
I was about to say, I think we do talk about it a little bit later.
Well, that's fine. Yeah, but let me finish that moment real quick. So she asked me to help with, can I get, as a law firm lawyer, so private practice, not pro bono all the time, or most of the time, or most all the time, we're trying to get fees. But would I find some time to help her on a pro bono basis with a client she had in a case she had? The case is so compelling. I was just drawn to it. And once I'd gotten that, I was like, tell me more, right? Because I'd seen some versions of that in my practice, but not kind of, this consistent channel of, these are the cases we do. It was really, really compelling to me. Like, well, say to myself, like, well, I love what I do now, but I can love it even more. And that's how I got into the work I'm doing now.
And you touched on it, that it was striking a nerve for your clients, and specifically more on you as well. But for someone who may not be seeing the nitty gritty, or might not have done the LSAT as a backup plan or,
I
understood.
feel embarrassed by saying that now.
No, it's okay. I mean,
no. I've always been gung-ho since age 2. Yeah, it's not how that quite worked.
Well, I mean, just for kind of just, I guess, the more everyday, civilian or American, why do property rights and public land issues matter?
How much time do we have?
We could really go into it. I guess in a more general sense. To the more everyday American, why should I be worried about my property rights and public land issues that are going on around me?
Well, our nation, I think, is set up specifically to acknowledge and honor and promote things that were denied. People who fought in the Revolutionary War, they were denied to those people, right? The idea that you can't have a tyrant just tell you what to do all the time. There has to be some check on that. There has to be some balance. And really so that you buy in as a part of the community. All right? We all live here together. We all can, this is me kind of speaking extemporaneously. I don't want to get too philosophical. I don't want to go John Locke. Evelyn, you mentioned that. I don't want to get too social contracty. But, okay, if we can agree that we do need someone who can help us as a community go in a direction, and we agree that we should be a part of a community, which I think most people do. Not everyone does, and I'm fine with that too. Like, well, okay, so let's put some constraints on there, though, because in my experience, at least, once someone has some power or authority, whether God-given or otherwise, right, they try to expand that and expand that and expand that. It's a kind of natural behavior, frankly. I could fault someone for it, but it's also understandable. And in the foundation of our country, the founders saw that too. They had a wealth of experience of living through it.
Yeah.
And recent history, whether they lived it or not, of how people dealt with that and decided, well, here's how we're going to set the boundaries, and we think this will work. And it's about 2 things. I kind of wish CAPE had an S in it because safety and security are important. I think that's one of the main premises of our Constitution. You didn't ask this question, but one of the main premises of our Constitution is not just prosperity, but safety and security.
Is that written in there?
No, it's not.
Oh, okay. General philosophical.
Yeah, exactly.
Okay.
I don't think prosperity is either, frankly. But maybe I'm wrong.
It's a long piece of paper.
Yeah,
it's a long paper.
It's also separate from the Declaration of Independence. There wouldn't be necessarily a reason for it to be in the Constitution itself, which is our guidelines for how we're doing this. But first of all, you have safety and security, and then second, you have prosperity. How are we going to grow? And we have to put these checks on the people who we're telling, we'll listen to you, we'll do what you say, within, I'm using my hands, I don't know if that's...
No, it's okay.
Within these lanes. We're all going to agree that we're cool with that, but stay in your lane.
Especially the government.
Well, specifically the government, yes.
Specifically the government.
Right? I mean, we have we have crimes for the rest of everybody. Right? Like, don't kill somebody.
That's a very specific lane.
Yeah, exactly. It's a lane. As for the rest of the crimes are for everybody else. The government is set up, they can be criminals too. Don't get me wrong. But with these 3 branches of 3 ways of approaching how are we going to move forward. That's prosperity. How are we going to move forward? And I think that the balances that were drawn there of, well, we're going to give you a lot of room to lead our country, but stay within this lane, please. You also have a lot of say in this. You're equally as important as the other guy. And here's your role. But please, stay in that lane.
Yeah.
And then you, there's 3 branches. And then you, so the third, right? This is the judges. Also, when there's a problem, help us figure it out, but also stay in that lane. Important thing with the judges, but do the job, right? Which I think you've seen a lot lately with the Lober Wright and 7 county decisions. A lot of Supreme Court telling judges how to do their jobs, which I think is a good thing, if I'm being honest. But I'm just drawn to it and drawn to that and tying it all together, hopefully. It's kind of an extenuated answer, but, I deal a lot with natural resources, the environment, energy, things like that. And you have so many chances to encounter the federal government or local government, state, county. And that's just a million opportunities to ask the question of, which lane are you in, and are you still in it? Right? Which lane should you be in, and are you still in it? Because Because if we're moving forward, that's fine. We understand. We all agree that you're allowed to do this, this, and this, but not the other thing. Mm-hmm. So if you're doing the other thing, let's check that. Let's check on what we're doing here.
Yeah, I like that, and I like how you kind of touched on, government.
Like it took 20 minutes for me to say that, or
no, it's okay. The government staying in their lane, as well as making sure that everybody is holding each other accountable, and not just the government and the DOJ holding the Davids accountable, but also the Davids holding Goliath accountable.
The accountability thing is important to me. Frankly, it sounds corny, but going back to actually, you mentioned this before, but coaching youth sports, right? Mm-hmm. Accountability among the kiddos, like when they start to see that each other is accountable to each other, which is hard to do for an 8-year-old, I think. But they start to you see them develop a sense of belonging together.
It's a community aspect.
But accountability is a part of it.
Yeah,
a big part of it, because they develop a trust.
Yeah, I agree.
They develop a resilience from that, which I think is important for our country, and I think that's part of what the Constitution is written for, right? For resilience. Like, it's going to be tough out here. Never mind, true. I wasn't alive during the Civil War, but I only look at.
We read documents, though. We got a lot of documents.
I read a lot.
Yeah.
Resilience is important, and I don't think you get there without some trust.
So kind of, I guess, sticking in that subject of keeping the government in their lane, if you had to name one trend, I guess, in government overreach that concerns you the most, what would it be?
Oh, that it's there.
It's there? It's there. The government's there, and
it's almost
period.
One of these things. I'm not even mad about it in a way. Right?
Yeah.
It's like, well, whoever has power or thinks they have power wants to expand that power. I feel like it's a natural kind of human instinct, frankly.
Historically,
biologically, I think that's why we have the Constitution, and that's why it's written the way it is. So, well, we all get it.
Yeah, I get that.
If you give someone some authority, and we're all as a group going to say, you can make the decision. Well, okay, that person's going to take that and I want to make more decisions. And okay, well, in this range, you're fine. Mm-hmm. But if you get outside of this range, you're not fine. And let's put up some guidelines around that. I just did bumper bowling with my kids.
You got to have bumpers. Yeah, you got to have bumpers.
We'll put the bumpers on.
I have horrible aim. Every time it goes gutter.
I'm not a good bowler, but I'm not a bad bowler.
But the government even needs bumpers. You know what I mean? Even if they're bad bowlers.
Hey, bowling with friends is fun. Bowling with family is fun. But you see, you see this idea of you have the whole lane here, but let's keep it in the bumpers.
Yeah. No, absolutely.
And a lot of people, when they get told that, don't like it.
Okay,
it's not on their agenda or mission to stay within those bumpers. Maybe they don't even see the bumpers.
That's true, especially when agendas change so much between administrations,
genuinely, maybe they just don't see it or whatever it is.
Yeah.
Right? They think they're in the right, which is totally fine.
Yeah.
But what if they're wrong?
Yeah.
I live to fight these fights. Say, well, actually, you're over here.
Yeah, and there's so many cases that happen all over the country, and Supreme Court is obviously trying to at least keep an eye on the ball and see what's going on around. But let's talk about maybe a time where the government may have tried to get outside the bumpers, and more specifically the water rights and Nevada Ranch case. I guess in a very broad essence, can you give us a breakdown of what that case is and why MSLF is involved, why you're involved specifically, and that's Baker Ranches versus Highland, I believe. That's how you pronounce it? Holland.
No, actually, and there are two cases that go together with that one.
Okay.
To be honest. So I can speak for another 30 minutes here.
Good. Let's do a general overview. General overview.
One of the things that people who have some power and authority tend to do is try to get more. With the special question of what do you do with water in the American West, where water is scarce and very valuable, that leads to a lot of fights.
In between who?
Among anybody who wants water, which is everybody.
Okay.
Right. So it can be private to
ranchers,
private. But the government is also just another fighter in that fight. In our country, even though we don't have kings, that's not a protest statement, it's just the reality of it, right? We still have the principle that you can't sue the government unless the government lets you sue them. It's called immunity, sovereign immunity.
Okay.
It's a key term.
I didn't.
It's a very lawyery term. Sovereign immunity. You can't sue the government unless the government lets you sue them.
Interesting.
That somehow has survived for a long time. Again, how many hours do we have is the question. But one of the ways that the U.S. Congress decided to say, hey, look, we're going to let you sue us is in water in the West, right? Because a lawsuit doesn't have to be so adversarial. It could just be about figuring out like who has what rights and who doesn't, right? But if the U.S. government says we have water rights out here in the West, but you can't sue us about it, that creates a real problem, right? Because
it's a snowball effect, isn't it?
Well, I mean, it's many effects. Sure.
A lot of fallacies.
Sure. Yeah. Sure. But what it does is have a situation where everyone is frustrated by the U.S. government hoarding all the water, which only increases the already heavy leverage the U.S. government has over the people. I mean, this could be a well-meaning federal regulator. I'm not trying to cast aspersions on the people involved.
No,
right?
absolutely.
But when you look at the totality of it, the aggregation of it, say, well, the government already has a pretty heavy hand out here, and now we can't get any water. That's a problem. So our U.S. Congress in the 1950s, I'm surprised it took that long, honestly, but our country wasn't settled until late 1800s, so, maybe these things take time. Decided that you could sue the U.S. government and make them come to court about water rights in the West. Or water rights nationally, but in the West is the reality of it. Baker Ranch, which you mentioned, is a case right now, along with another case we call it Idaho Stock Waters, the U.S. v. Idaho, where the federal government decided, well, we're trying to find some loopholes around this direction from Congress that says that we have to be on a level playing field with everybody else when it comes to water in the West. But the reason why Congress put that in there was because they have to be, this is such an intense, important thing that we need the federal government to be on the same playing field as everybody else in the West when it comes to water. So Baker Ranch is a case out of Nevada, a family who's been ranching in eastern Nevada for a long time. It's actually Baker Creek, although it's not the Baker family.
Okay.
But there's a creek that flows into eastern Nevada that when people were moving there, they went to the court together, like, hey, let's get a final judgment we can all rely on, right? A piece of paper that says who has what rights to what water out here in this otherwise arid area. Weird to say arid area. But but let's get a piece of paper that says, like, well, at least so we don't fight, right?
Yeah.
Let's just get someone to, like, rule and, like, all right, well, you get this much water, you get this much water.
Stay in your lane.
Stay in your lane. Everyone stay in your lanes.
Put up your bumpers.
Yeah,
Go on now.
Yeah, put up your bumpers. But at least we all know what the deal is.
Yeah.
Right? You'd be happy or mad about it, but at least you know what the deal is. And the government chose not to be a part of that. They chose not to be involved.
Can I ask why?
Well, I don't know why.
Oh, okay.
I mean, if I was them, I wouldn't want to either, because
you're already looking over so many other things.
Well, separate from that, because you want to say that you can't touch me, like a little MC Hammer moment. Like, yeah, you can't mess with me. Like, we're the government. We can have all the water we want to. So they chose not to be, and I don't know if that was their motivation this time. I think generally, as I'm seeing these cases, again, the cases I'm talking about are both on appeal at the Ninth Circuit Court of Appeals. I mean, these are issues that arose 100 years ago, 150 years ago, and are still here. Government chose not to be a part of that. And then time goes on, decades go by, for better or worse, I'm not here to judge that. The government said, well, this part of the land is federal land. Wholly different question. You haven't written down probably, but whether the government can say that in the first place, different question. We can get into it, though. Again, I have all day. So the government said, well, hey, we weren't part of that, and we're creating a national park over here. So we're going to take all the water we need for that park, and we don't care about your deal. Your adjudication from a court saying who has what rights. We don't care. We're the government. We're going to create this park, and your rights don't mean anything to us.
So did they dam it like early, like
not
up the stream?
Not at first, but over time they have. Over time, they've restricted the flow of water to our clients in eastern Nevada. Our clients try to take it in their own hands and go reinvestigate that flow, maybe reinstate it. And they got a lot of pushback, and it's turned into a long, sprawling lawsuit. We only came in sort of kind of at the third quarter, if I'm being honest on that one. Right? They've already been through like federal court, appellate court, federal court. They've been through some processes. But we're here at the Ninth Circuit with them fighting over this question whether the U.S. can say, well, we never really took part in the first place. When you guys all adjudicated who has what water. Adjudicate is a weird word to say. So we don't have to now. But Congress made a law, called the McCarran Amendment. It says, well, no, we understand, government, that you keep doing this, and we are the government too. We're not going to do this anymore in the West, right? Especially like you're just another water user in the West. You can't opt out of that, right? So if these guys have a right that goes back to the 1880s or 1960s, whatever it is, you just have to know that and then comply with it. You don't get to like find some workaround.
Yeah.
That's what that case is about. Idaho Stockwater, I know you want to move on. Idaho Stockwater is actually a very similar thing. In Idaho, according to the Idaho Supreme Court, water in Idaho, including water and little ponds for water and cattle, that belongs to the state of Idaho, not the federal government. No one argues about that. The federal government doesn't argue about that, actually. And about 20 years ago, the Idaho Supreme Court said, okay, well, our rule in Idaho, as is through most of the West, is we don't have a system. I don't know if people who live in the eastern part of our country realize this, where you don't own the water by living near it. You own a right to use the water when you use it. Right? So whoever kind of is a way of like prioritizing.
Yeah.
Like, well, this person's using it. That's like, how do we value water? Give it to the person who needs to use it the most.
Yeah.
And they're doing it, right? Not just like hypothetically, but they're actually doing it. It's called beneficial use. We call it appropriation out here in the West, right? They're appropriating the water. They're actually using the water for beneficial use. Well, these livestock ranchers are out there doing this all the time. Eventually, the U.S., again, we set aside whether the U.S. should or can own federal lands throughout the West. I just did air quotes in front of the microphone. I don't think the microphone captures that. But, the U.S. is, well, we have a lot of land out here. We're gonna give licenses and permits to these, ranchers to graze their water out here, or graze their cattle out here. And of course, they need some water ponds for their cattle to drink water. Okay, fine, that's all good. Say, well, when it comes to a fight over who has a right to use the water, is it the U.S. or the ranchers? The Idaho Supreme Court answered that and said, well, the ranchers are using it. It's their water, right? This isn't like U.S. water just because it's on U.S. land. That's not how it works in the West. Right? You have the right to use the water because you actually use it. If the federal government wants to like buy a bunch of head of cattle and put them out there, fine. They can own the water right that way. But they don't do that, and they don't want to do that. I mean, I don't know why they don't want to do that, but either way, they haven't done that. Idaho created a set of laws about 4 years ago. Well, it's been a rolling kind of thing to kind of emphasize that. Hey, don't forget, as a matter of law in Idaho, as our Idaho Supreme Court said, these waters in Idaho are Idaho waters, not federal waters. So our Idaho law applies. And you have to use the water to say you have a right to use the water. The U.S. government does not like that. They would rather have all the water.
Does that touch on the idea of like state sovereignty?
Yes, very much so.
Okay.
Yeah,
okay.
so. Thanks for asking that. But
No,
a little 10th Amendment action here.
Word.
and equal footing action, which is, again, what I've alluded to a few times.
Yeah, no, I get it.
And so we're in a lawsuit right now where the U.S. government sued Idaho for creating these laws that just put, in writing in a law code as opposed to being like some case decision somewhere, which I know where it is. But, these are the rules they've always been here in Idaho, right? Yeah. Here are the laws. The U.S. government is like, well, they say they want the water. It's like, fine, use it. Well, no, we don't think they should apply to us. Like, well, the McCarran Amendment is what I talk about. Like, the federal senators in Congress decided, well, you had to play ball with everybody else in the western states when it comes to water. You're not immune from getting into these fights. And they're saying they're immune to these fights. You can't even pass this law. You can't drag us down in here. You can't be involved with this. We're the federal government. We have the water. Like, that's not how it works. That's how you start with Baker Ranches, which is the Nevada one. Yeah. This is the Idaho Stockwater, is the Idaho one. But they're both fully briefed at the Ninth Circuit right now. I just got an email, I think, yesterday about setting up arguments, which I'm excited to do.
Get in the arena.
But it's kind of getting far away from some of the things we're talking about. That's what those cases are about, though, is, again, cooperative federalism, as you mentioned, right? Federalism is what the word you use. That goes hand in hand with this sense of drawing lines, drawing boundaries. And it could be well-meaning people on the other side, but the boundaries are there. And it's not always easy to fight against the federal government. But I'm here for it.
Yeah, and I mean, even to expand on this, and I mean, kind of another little pivot is, I saw that you recently testified in, I believe, 2023 in Alaska about
Alaska, yeah.
About property owners facing sweeping control over their land. So what does that case illustrate about modern conflicts between landowners and government entities?
Well, they're not going to go away, right?
Yeah, it seems not. It seems like they're going to put up a fight before they do anything. Exactly.
If you want to stay busy, be a lawyer, because the fights don't go away.
Yeah, DOJ needs something to do.
Alaska, you asked that. Alaska is unique, so I don't want to get too carried away there. But the principle that the issue in the case you're mentioning, it went to the U.S. Supreme Court on a request for review, and the Supreme Court denied it. Called Flying Crown. It is, I think it was denied because it was by the U.S. Supreme Court because it's kind of parochial to Alaska. But this idea of the U.S. to foster and support the building out of the Western United States from the east to the west, made a lot of land available to railroad companies because that was the way to get around. Like, we want people to move
commerce.
Out the west. We got to get them out there. Oregon Trail would have been a lot faster if you just got to ride a train out there. And bears weren't out there all the time and dysentery.
A lot of other things, but yes, so we could have used trains.
I don't even know if Oregon Trail's still around, so that might be a bad reference. I don't know. Anyway, it would have been faster with the train. The U.S. wanted to promote building rail networks out in the West so people would actually move out here. And in doing so, they gave certain, not all, but certain property rights to the train companies in the states and kind of as they're the territories at the time. It's like, to help you want to build this, let's make it easy for you. And that's led to a lot of conflicts down the road. Because what did that right entail? The Alaska question you're asking, Alaska case you're talking about is, when a train company gets this right to build a railroad track, they don't actually, in some places, they actually own the whole land, from hell to heaven. There's a Latin term for that, but I'm not going to do it here, even though I like it. It just wouldn't sound right. But in another place, they didn't, right? They just got, we'll give you the surface right for this part of track. At least you can keep building it, right? We can't give you company, like literally all the West to hold forever. But so the nature, so what is that right? When the U.S. government gave you this right to build out the United States in the West, Alaska came around 50 years later, and there's a big question about whether the same scope of rights. Now, this question actually is a Mountain States question. We went to the U.S. Supreme Court on this one. And one on limiting, getting the court to recognize when the U.S. gave railroads in the the lower 48 West, how about that? Lower 48 West, easements is what it's called, but rights to go across someone's property. Those were very narrow. It's like, to build your railroad, you can maintain it, right? Keep people safe. But we didn't give you a right to keep, because you're building it on someone else's property. Yeah. Right?
Building through someone else's property.
We're going to sell that property. They turn around, the U.S. turned around and sold that property to individuals, build your ranch here. Yeah. Right? Except, this railroad's going to go through here. Yeah. Fine. We get that deal. We'll take the property. Good advice, by the way. Take the property. But so if you're the railroad and you're on someone else's property, but you got this right from the government, what does that mean for you, right? How far can you flex your muscles? Yeah, it's not. It's pretty close to the same question we're talking about, the lanes among the different branches of government. Well, how much can you flex your muscles? And at what point you're not there.
Yeah, you got to put some bumpers up.
So that was not Alaska case about, although it has some unique Alaska aspects to it. But we had won a case about that involving the lower 48, actually Colorado-Wyoming border, nearby.
Yeah, and I like how a lot of this.
I don't think you expected that answer, but
no, it's okay. I mean, that was a general education that I needed because I was very confused on what was going on. But it's one of those things where even if you're talking about free speech or gun rights, just presenting standing and actual harm, but not just on ranches and I guess smaller entities, but I guess on the broader population. It's not just affecting Alaska; it's inevitably going to affect more farmers, more ranchers, more states, and it's just, again, kind of this going back to this snowball effect. So, yes, that was the answer I was looking for.
I get so excited to hear you say that.
I'm understanding it now.
I'm trying to step on your question.
It's happening.
How do I let him finish this point?
No, it's okay.
No, that goes back to the first question you asked. Why am I doing this, basically, is synthesizing your question. That's why. Because it's not.
There's a bigger problem here.
Well, there are real people hurt here. We want to help them. And if we are successful in doing that, there's a bigger point that should hopefully carry through as a ripple effect of the country going forward.
Supreme law of the land.
And it might be a thing that was always true, but people lost sight of it. Or it might be a new way of looking at things, which is more correct. It was always correct. Going back to like my master's degree in math and statistics, like, well, there's a B hat out there and a B there. But yeah.
So I guess it's okay. we're gonna keep calling it back. And MSLF had a recent win in 2023, protecting access to the Rio Grande National Forest. Why is public lands access becoming such a flashpoint within the natural resource realm? And what is it, the Fifth Amendment? Fourth Amendment?
Fifth. But the natural resource access things are more about, again, staying in your lane. And I've referred to this a few times. If the federal government can say that we own the land out in the West instead of having to give it to the states, an active fight still. There was a request by the state of Utah a year and a half ago. I think it was a year and a half ago. To look at this issue again, and the U.S. Supreme Court said, "No, we're not going to deal with this." They didn't say why. It's a very lively issue about whether the federal government can actually have federal land in the West, but the federal government has tons of land in the West. Assuming that's correct.
Yeah.
Let's take everything I'm saying. Assuming that's right. Yeah, exactly.
Hypothetically.
Let me not say that I'm not fighting that, because we are fighting that. Assuming they can. Well, then now we have to figure out, okay, Congress then has the power to deal with American lands in this nation, capital N nation. What do we do with that? Well, Congress made some rules about it. They put them in statutes. They're laws. And overwhelmingly, those laws focus on managing public lands, like public as in, owned by the government, so owned by the people, managing those lands for the people and letting them have access to those lands. And Rio Grande, that's a kind of a niche example, but like even just now regulatorily with the different, administrations, you see, which is not surprising, a federal government that wants to say, actually, those are our lands, you can't touch them. Those are our lands. Well, that was never the deal, right? And again, it could be any, this is not a political statement, right? It could be any administration of any, I'm not a very political guy. I'm here for the Constitution stuff.
Yeah.
Well, we're going to decide that we're the government and we can take those lands away. So, well, that's not, Congress, which most directly represents all the people in the country.
Yeah.
Painfully sometimes, right? Like, there's a reason why it's slow. Like, well, because we got to get a consensus to get all this stuff done.
Very many different walks of life.
Somehow decided that, we should manage federal lands, so public lands, for the public. And that means multiple uses of those lands, not just taking them away from the public, right? We're managing them for the public, not taking them away from the public. And over different decades, and again, it's a blessing to live so long, different administrations have tried to take lands away from the public, despite what Congress said has not changed in the law, 50 years ago. Not quite, but we're right around there. Congress said, we're going to, we as a country, we've all decided we're going to manage these federal public lands for the public for multiple uses and to sustain them, right? So there's a thought of we're not going to destroy them, but for multiple uses, and they're actually Congress wrote out a priority list. It's not exclusive, which is leading to some current fights. We understand we have forests, we need timber. That's good for people, right? It's good for developing the West. Hey, we have mineral resources out here in the West. That's a priority use of federal lands is to get those minerals, get that oil and gas. Grazing. We have a lot of ranchers out here, and that's a really important thing for our country. So we're going to prioritize, federal government regulators, prioritize the ranchers' ability to use lands in the West. Until you get a new executive administration, we didn't write those laws. You have to follow them. But we didn't write those, so we're going to do something else. So actually it started in the 1990s. It didn't start there, but in the 1990s, the presidential administration at the time created a series of, or a category of grazing leases. Right? We the government, we say we own all this land, call it in Wyoming or wherever. But we do think grazing is important. We'll issue, you private rancher, we'll let you come onto federal land and graze your cattle. but what if we created a grazing lease that didn't let you graze your cattle? Right? Because it's not a real grazing lease, right? Because we want
counterintuitive.
We
almost.
want no one to go on this land. Mm-hmm. So we'll give you that lease, right? Or maybe the highest bidder can get that lease and lock away lands and not let anyone use them. Mm-hmm. That was like 1995, 1996. And luckily the courts, or not luckily, I mean, correctly, I think would be a better word for it. The court said, well, you can't, the law says that these leases are supposed to be for grazing. So you creating a grazing lease that is not grazing is insane. We're not going to do that. A couple decades and administrations change, pendulums swing. And the most recent presidential administration before this one said, well, we have another lever we can pull here. What if we just say that the law which governs how BLM is allowed to, probably Interior, but BLM is allowed to manage federal lands. This is the one that says multiple uses, right? What if we say that one of those uses is conservation, and we're going to enable ourselves to decide that? That's not Congress speaking. Mm-hmm. That's the regulators, right? The regulators, but that's we're going to read the law that way. And it's like, well, that's a point of departure because Congress really clearly was about using the lands.
Yeah.
Right? And not, well, using as conservation's using, and we're going to take those lands and no one else can use them. So, well, that's not multiple uses. That's not multiple. That's just not, it's not in the statute, it's not a thing. But it becomes flashpoints. It really affects people in the West. Again, it's so hard sometimes, not hard, but like interesting sometimes that there are people in this country, which is a big country, right? Beautiful, big, beautiful country, that have no sense for what everyone else is dealing with.
Yeah.
And I'm sure there are people in the West who don't realize what people in the East are dealing with to make it easy dividing line. I think Mississippi River used to be the dividing line, but now I think it's I-35. I go to Oklahoma, though. I-35 goes right there. You have no frame of reference. It goes back to the water rights thing, right? The water laws in the West are different from the East. The effects of government control over land use in the West are different from the East because there's so much more government.
Yeah, I mean, a lot of these laws seem like they've been made over 40...
You're letting me whine and tangent.
No, it's okay. It's 40, 60, 80 plus years now, and it seems like a lot of them are starting to kind of come back and bite you in the butt, or I guess from a government point of view.
Well, I mean, patience is a virtue, right?
Yeah,
I mean,
patience is a virtue.
And sometimes it takes time to flesh out, like, what is the problem here? Yeah. Like, what is the real core problem here? So that's not surprising to me.
Yeah, a lot of
we still have questions about the First Amendment, right? The Second Amendment, like those.
True.
Those have been
principles.
there longer than these congressional, like written down laws, which is actually kind of why I always my work goes back to kind of more of the foundational separation of powers questions, right? It's not just about when the law was written; it's about who gets to decide, and how we all agreed, hopefully as a country, about how to like let someone decide for us. Yeah. And how have we decided they can't decide for us?
I don't think a lot of people like wrap their head around the fact that like laws are also made out of, I guess, the essence of the time, you know, a sign of the times, like, and especially because times change.
Times change, and that's what going with the principle. I mean, the founders, and you can see this throughout, whether it's the Federalist Papers, the Constitution, right? The people who did that had about 200 years before of a unique experience also, collectively. I don't think anyone lived that long, but... And so they had experience to build on, but then also we just fought a war with the country where we're from. How do we do this is a question, right? Like, how do we do
Where
this?
do we start?
Where do we start? Like, well, how about don't let the troops come into our house all the time? That's one thing. Yeah.
And we get guns.
That's one of the amendments we don't see fought very often. It's quartering. But, you know, they had some things in mind. Like, well, we're not doing that anymore. You know, just getting thrown in jail without any charges against you. Like, that's not a thing. So, you know, a lot of people don't like that it takes time to do some things and to get it right, and to find the right vessel for it to make sense to everybody. I have so much respect. It sounds like pandering. I don't mean that for our U.S. Supreme Court. Like, you get frustrated sometimes when you don't take a case, but like, well, maybe it's the wrong vessel, right?
Yeah.
And if you want to get things right, you want it to be all the way right, and that's hard. Hard to do, because one of the beauties of our system is that we don't let our courts, our judges, just make up stuff, right? They're there to deal with a fight that's in front of them and dealing with that. If it has some broader point, great, fine, right? But they're not out here overruling Congress or overruling the president on things that aren't, you know, direct fights put in front of them. And I have a lot of respect for that restraint. Say, hey, look, we're just going to deal with this when it gets to us the way it does. And from there, we can decide, okay, well, who's right, who's wrong, or what was the right way to look at this? If it has a broader impact, it has a broader impact.
Yeah. When you're at SCOTUS, I mean, the decisions you make quite literally impact millions of people, possibly. So you got to make sure you get it right.
Well, that's why I said I appreciate the restraint, because, it's very tempting, certainly as a law student. It's always fun to read the opinions that are like broad brushes. And some of those are appropriate, and some are like, well, if you look at it, you really didn't have to do it that way to solve this problem. So what are you doing here? Why do you get to choose?
At the end of the day, yeah. And I mean,
But at least if it's a majority opinion, they have at least 5 of them at least.
Yeah, and I mean, looking back at kind of going back to what you've done as well, it looks like you've kind of written about these concerns in what looks like an executive authority paper, talking about the Antiquities Act. Kind of going back to this essence of like, sign of the times changed, but it's affecting us now. So in the simplest terms, what is at risk when executive power goes unchecked? And this is kind of touching more on your Antiquities Act paper, your executive authority, stuff like that. So,
okay.
Yeah, let's start there. Actually, what is the Antiquities Act? And
what is the Antiquities Act?
Let's explain that for people who may not know what that is.
Like you?
Yeah, no, you're right. No, I tried to.
That was me.
Listen, I tried to Google it before.
It was funny, but
no, it's true. It's true.
The Antiquities Act. So Congress has the power to deal with federal lands. And in 1906, Congress decided to give President Teddy Roosevelt the power to do some of that work. And Congress can delegate some of its authority. Congress makes the laws, as long as it's not fully delegating its like actual duty to make laws. It can give some to the president or somebody else, or mostly the president.
We'll give him a job or
two.
two.
The Antiquities Act is that. Congress said, hey, look, President, if you find like a really important monument that needs to be protected, we'll let you. It's on federal land. We'll let you say that no one can mess with it. That's your job, President. Like we're usually it's our job, Congress. We're going to give you that duty and authorization, President. As long as it's 2 things. One, it has to be an actual thing.
Yeah.
Like a monument, an object.
Historical significance.
Yeah. And 2, we get it. Like we don't want someone standing like 5 feet away from that throwing eggs at it.
Yeah.
So we'll let you, in going to this, uses of public lands, we'll let you create a buffer around it. But the smallest buffer, keeping people away from it, that is compatible with protecting it, right? So not like you can't say, hey, this pottery over here is pretty important. That's pretty cool. We're going to leave it there. And for the next 200 miles, no one can be near it. Well, that's kind of weird.
That's a little excessive, right? Yeah.
And that was the premise of the Antiquities Act. It was like, hey, look, and it really started with people were looting Native American sites out here in the West. So how do we protect these? Like, we don't even know, cultural heritage-wise, I think the government, we don't even know what's going on out here. But it's not cool, right? So we need to and Congress can't act fast enough to deal with it itself. All right, President, you go deal with it because you can act faster, right?
You love national
We're going to give you some room to run. We're going to give you some room to run.
Yeah.
Here are your bumpers. But within these bumpers, go protect these monuments.
Start writing things.
Go protect these things.
Yeah.
And that's what it happened. Is the president at the time started to say, hey, well, that's off limits. That's off limits. That's a Native American spiritual site. Don't go near it. Give it a 10-mile buffer. You can go there, but you can't, for example, raid it with your cattle, right? You need a little more protection than that. President Teddy Roosevelt, I think maybe to his credit, decided that the entire Grand Canyon was a monument, but Grand Canyon is pretty amazing. I mean, I've been there.
It is pretty cool.
It's one of these, what's this all about? You're like, oh, I get it now. It's amazing. But that kind of expanded the scope, right? Beyond just well, there's this cool old pueblo over here, and it's probably pretty important. Let's protect it. To bigger ideas of what a president can do with this power given by Congress, right? It's not a presidential power from the Constitution. That power goes to Congress actually to do that. And Congress said, well, in these situations, we'll let the president do it. We wrote a law about it. It's in the law. But it has to be the object. It has to be the smallest area to protect the object. And that has gotten way out of whack.
In what sense?
In the sense that presidents do not feel bound by the idea that it's an object. And they do not feel bound by the limitation that has to be the smallest area compatible to actually protect that object. So we have several cases about this.
So they're using more or writing
yeah.
off more land than
they're taking
necessary.
more land away from the public.
Okay. So public use of like oil rigs, farming,
just even hiking,
mining. Oh, hiking.
Oh yeah.
Okay.
They're taking the land
completely
away
written
from the public.
Okay.
And there are different ways that kind of manifests itself over decades, but that means all things are off the table potentially to protect this object, and yet they can't even identify the object yet anymore. We have a case, the Chuck Wall case, where the object, maybe there's an object there, maybe. I don't think so. But also, we're going to take away most of Southern California from public uses. Like literally, if you like do the dividing line around LA and go south from there, which is not quite in California, but like think about LA and go south from there, like half that land's gone. Public can't use it anymore.
Just because of the monument.
Yeah, which monument? I don't
Allegedly.
know. We don't even know where it is. Yeah,
Allegedly.
exactly. Where is it? Well, I don't know. Why is this
Somewhere
the
in
area
there.
needed to protect it? No idea. So we are suing. We have sued, and we are litigating. Whether the president could appropriately, whether that fit the law, right? Because this is not the president's call on this one. Congress gave this power to the president, put bumpers on it, right? Again, it's like, well, you're not in the bumpers anymore. So we again. It's related to all the work that we've talked about, but that's unique.
And it's kind of bleeding into, exactly what CAPE is, the essence, the core principle. And then,
hey, we're about American prosperity for sure and energy.
yeah.
I haven't said affordable, reliable energy yet, so.
No, and I think now it's kind of, we've talked a lot about the stuff that we're doing here, doing now, but we can even talk about CAPE and kind of what could go forward if CAPE wasn't here, MSLF, or entities like MSLF weren't here. So where do you think courts should draw the line between, I guess, legitimate executive action and then overreach?
Oh, the Constitution.
Constitution.
Yeah, that's
all right.
That's pretty good.
Pretty simple.
The lines are there.
Yeah. All right. Next question, actually.
Yeah, exactly. Yeah. So, so again, this actually is the good example of that, right? The Constitution says that this branch can do this branch can do that, this branch can do that. And what if one branch says, well, within our power to do what the Constitution says, we can give another branch some power? Okay, well, that's, sure. But it's still going to be limited to, like, within your own power, Congress doing that. And then whatever you say they can do, they can, the executive branch can do. They have to stay within those boundaries. Most of the fights we have end up being, as don't sound exclusive, against the executive, federal regulators, right? For either reading the law a way that we don't think is appropriate, or frankly, just not reading the law at all, in deciding they have power to do a thing X, Y, or Z. Yeah. And, well, no, we've read the law and you can't do that. And, well, but we're the government. Well, yeah, no problem there. We get that. Check. Yeah, get that part. But you can't do what you're doing. You can't come on this property and tell the landowner what to do. You don't have any. This is not your land, federal regulator. It's their land. We don't have like these free roaming federal police to go around telling everyone what to do all the time. That's part of our system, the way it's drawn up. You get back to the 10th Amendment. Like, even the states don't have that, but they have it more than the federal government does. And we really respect private property and private property rights. And individuals out here just trying to live. And unfortunately, or fortunately, I guess, for the work we do in a way, I guess you can say it that way, is not everyone feels like they can fight. When they've been pushed around. But I can do it for them. So I do that.
That's why we love Ivan London.
Should I face the camera on that?
Yeah. There you go. Boom. There you go.
Yeah, exactly.
But yeah, it's awesome to know that people are fighting, and that I feel like the window that we're highlighting is a very small magnifying glass. It feels big, but what we do here, it can sometimes look like a very small window. But are there any other cases, maybe that we didn't discuss, that you're keeping an eye on, that you think more Americans should know about, that might either soon to be affect them or already affecting them?
So I'll rehash my corner joke. We have 3 hours, right? One that comes to mind, I think of cases kind of in 3 kind of different buckets, even though it's a generalization. But one is legislators behaving badly. Right?
Okay.
People who make the laws. It's Article 1 of our Constitution. People who make the laws behaving badly. And one of those we have right now, we are co-counsel for plaintiffs suing the state of New York because their legislators decided they could create a penalty for oil and gas companies, energy companies, for behaviors either those companies did or didn't do, dating back decades, just to produce oil and gas, whether it was illegal or legal or not. And to say, well, because you did this, because we in New York think we have some harms from climate, vaguely, not like this harm, like some harms, maybe, question mark. But you were an energy company then. Therefore, we can fine you basically up to $75 billion for the next.
That's West Virginia, right?
It's called West Virginia v. James. So there are several states involved. Like I said, we're co-plaintiffs. We represent a really great trade organization, the Gas and Oil Association of West Virginia on that case. But we're partnering with the states saying, well, that's not right. You can't say that something that was totally legal in another state and nothing to do in New York 20 years ago somehow gives you a right to punish energy companies, get fines from energy companies, billions of dollars of fines from energy companies.
Yeah, that are thousands of miles away.
Exactly. You can't trace anything they did to you, even that's assuming they did something, right?
Yeah.
Assuming maybe it was illegal or not. Who knows, right? But you've just decided you can go send them a bill. And if they don't pay the invoice, you're gonna like bring them to court and put them in jail. That's an extreme version of it. Like
it's true though. You need the evidence.
So that to me is like legislators gone bad, right? Behaving badly. It's not federal. We don't only do federal work. I want to be clear about that.
That's true.
Wait, federal government the federal government's a lot out here in the West for sure. But we also, when state legislators or regulators act badly, we were there for that fight. When local, we had an issue here that we helped a local client here in Lakewood, Colorado, deal with their city council and fight on a property matter. Right, so we cover all those things. But that's one bucket. The other one, the most obvious one we deal with the most is regulators gone badly. Right, this is where the law says this, but you're saying you can do more, and we push back. We have a great case. Ace Black Ranch is one of my favorite cases. I mean, they're all my favorite cases. Kids, but although I know which kid is my favorite. Just kidding. I don't know.
It's like his kids. This is actually
but this is a huge issue even right now with Clean Water Act jurisdiction. Like I said, we don't have free roaming police, right? The federal government's bound by boundaries, whether it's metaphorically in the lanes we talked about or literally on the land when EPA or the Army Corps of Engineers asserts authority in the Clean Water Act. It's like, well, is there water there or not? That's what the Sackett decision said. Well, there's be water there. You can't stop doing this, guys. And that has not convinced the EPA, for decades, but even since that decision. We have a case about that where we're defending a ranch that got sued by the federal government for doing things that we say the government had no authority to say yes or no to, right? None of their business. We got that case dismissed, actually, but it's been refiled. And we're in the process of kind of figuring out the next steps there. And then there's this, just we don't do these cases as often because they're rarer, but these things come up, like cases about judges not doing their job. I have a ton of respect for federal judges, and it's a hard job, I think, but I haven't done it before. But when you look at the Loper-Bright decision and the 7-county decision from the last couple of years, which happened to be, energy, natural resource, environmental issues overall, administrative law questions too. You see the Supreme Court trying to help federal court judges do their job and also say you can't shrug off your job. You can't let the government win reflexively, right? You guys are the wall. You federal judges.
You have no opinion.
You're the ones who are protecting the people the most from the executive branch and even the legislative branch. Yeah. You can't just shrug that off. You have to do it. Now, the flip side of 7 county is actually, but also, you're just the judges, right? Let those guys, if those guys are doing their job right, let them do their job and don't overrule it. So there's a balance there. But we get involved a lot, and I get involved a lot in the cases that are about judges and how they do their jobs. Again, I have a ton of respect for it. It doesn't seem like an easy job, but so that's kind of the buckets I think about when you talk about extra cases. We haven't talked about already that they're not extra to me. They're hugely important to me. But
they're all important. That's why we have Mountain States Legal Foundation. But I mean, it goes back to that comment you said earlier about federal courts and Supreme Courts checking those, like you said, state judges, district judges. So does that give you hope as to look, I guess, for the future of constitutional liberty?
Oh, of course I have hope. I mean, we fight it every day because we have hope and we know that the whole thing works. And there's going to be fights. That's the way it is. And luckily we have people to fight it. I mean, that's kind of self-aggrandizing, but we're here to fight it. So It doesn't bother me that these questions get asked, right? They should be asked.
Yeah.
But what are the boundaries? Talk about the bumpers. Where are the bumpers?
Yeah.
That's a good question.
Everybody needs lines.
Right? Because they are metaphorical.
Yeah.
Like, the waters thing is different because the water's like that.
That's a literal
either
line.
water there or
Yeah.
not. Yeah. But the bigger one, the stay in your channels kind of thing and stay in your lanes, like, well, it's an abstract idea. We should have fights all the time about it. Right? Figure out where the lines are. I have a pretty strong feeling for how I think the lines are drawn. And I'm here to fight for that.
Do you think there's anything we didn't discuss that you think people should know about?
Not really. I mean, we're here to do the work. I feel like I've talked
That's
a lot.
good.
I know.
That means I did a good job.
No, I think you've done a great job. You've made me feel comfortable. This is my first time doing a podcast, so
You did a beautiful job.
Hopefully, anything I said was coherent. At least one thing. Maybe you can pick one thing, but
I think there's a couple coherent, like a lot of coherent stuff in today's conversation.
Frankly, we could do this for hours, and I'd be happy to. I
could.
love talking this stuff. So, well, how many hours do you have?
Well, not too many right now.
Okay. You and your boundaries.
I know. Hey, everybody's got lines, even the government. So, if you were to leave listeners with one question or one piece of advice / comment to think about from today's conversation, what would it be?
Oh, just call me. It's not, like if you feel like you're getting pressed, pushed around, it doesn't mean like every case is a good fit for us, or it might not be a pro bono case, or it might be because you're mad about your neighbor. We're not doing that stuff, right? If it involves some government actor, though, and you're getting pushed around, or you feel like you are, feel like something's not right, just give us a call. Like, we take in, and I wish we had 1,000 lawyers, right? We don't, which is true, unfortunately. There's so many. You're probably right, and I'd like to hear it and see if I can help. Yeah.
If we don't do it ourselves, we might know a guy or a girl.
That's true. One of the good blessings, like I said, it's weird feeling older now, is that I know I've made a lot of friends. And if I'm not the right fit, or if we can't help you out, I could probably help someone find someone who can. Not necessarily that's not my Mountain States plug. It's more like my personal life plug. But I'll go abstract for you. Being a lawyer is a service job. We're nothing without our clients. Our system in America, legal system, does not have people going around making points. You can do that you can do that on Twitter, right? We deal with fights. That's what our system is designed for. And I'm here for it.
Beautifully said. I honestly could not have said it better myself.
Blush.
Yeah. Well, Ivan, thank you for joining us. And
this has been a lot of fun, actually.
Yeah, and your insight was amazing.
It's a lot of fun.
And especially doing the ongoing fight to preserve our constitutional freedoms. And honestly, I enjoyed this conversation. I hope you enjoy this conversation as well as much as I did. But if you want to hear more, if you want to see more, make sure to subscribe and follow Beyond the Bench wherever you get your podcasts, and visit mslegal.org to either submit a case.
Hey, I'll get it. Yeah. It'll come to me.
Yeah. Or just to learn more about how you can stand with us in defending the Constitution. But with that, my name is Noah Diasicow. This is Ivan London, and we will see you next time to go Beyond the Bench.
I'm glad you didn't ask me to say my name.
There we go.